Your Honor, while Mr. Carodi is here, I wanted to bring up one small issue, and it has to do with the court's order regarding the timing of the filing of the motion in limines.
I can adjust it.
The state's thought process is we're going to be in trial when their deadline is. So I understand there may be things that come up during the Fernandez trial that causes the defense to file a motion in limine.
Tell me what the overlap is.
It's 5 days. So it's 5 days before the commencement of each jury selection. The state's thought process is some of the motion in limines will overlap, and as practical as we can make it, I would like the Gardner motion in limines to be filed 5 days before the Fernandez motion in limines. So in other words, we can hear them all at the same time. Understanding there may be something that creeps up in the trial that we have to hear, but I don't want to be in this situation where the state's in trial and the defense is filing motions in limine that we have an opportunity to respond to or litigate.
It is not always the spoken objection that changes a trial. Sometimes the objection is never voiced. Sometimes the record simply contains what it contains, and no one in the room needs to say a word. That is what happened on July 13th in courtroom 407, when a prosecutor stood before a judge and said, "I don't want to be in a situation where the state is in trial, defense is filing motions, and we lack an opportunity to respond." He was worried about being unprepared. He was worried about motions filed during a trial. He was worried about the defense having an advantage. But the judge had already addressed every one of those concerns, and she did so without raising her voice, without issuing a formal ruling, and without making the prosecutor feel foolish. She simply kept talking, and the silence that followed her words became the most telling objection of the entire hearing. The case before the court involved Mario Fernandez and Shana Gardner, two individuals charged in connection with the death of a Microsoft executive. The details of the killing are not the subject of this hearing, but the procedural machinery that will determine their guilt or innocence is. On that July morning, the parties gathered to discuss discovery, witness testimony, and the looming trial schedule. The judge opened with the usual civilities, a chorus of good morning, names entered on the record, and a brief technical glitch when one participant could not hear the proceedings.
Thank you. Good morning.
Morning, Your Honor.
Good morning.
Christina Sifler, Alan Mizrahi, and Steve Siegel on behalf of the state. We're here on Shana Gardner, number 9 on the court's calendar, and Mario Fernandez, number 4 on the court's calendar.
Thank you.
Good morning, Your Honor.
Good morning.
My name is Jesse Dreiser. I represent Mr. Fernandez, who's present and sitting at council table, along with Ms. Day, Mr. Hill, and Frank Tassoni, who is appearing via Zoom.
All right. Thank you. Good morning.
And Your Honor, for the record, next of kin is present via Zoom as well.
All right. Thank you.
Good morning, Your Honor. Patrick Brody for Shana Gardner, who's present for the court. Also, Ms. Nelson and Ms. Medina, counsel, are on Zoom.
All right. Thank you. Good morning.
And Your Honor, since our
Wait. Ms. Nelson, can you hear us? Ms. Nelson.
Good morning. I
Okay.
apologize. We're unable to hear the proceedings.
Okay. Can you hear me now? It's Mike, can you come up?
Your Honor, I think it may be on her end because we can hear.
Okay.
I'm going to ask Frank if he can hear us.
Mr. Tassoni?
Yes, Your Honor.
Okay.
Frank can hear us.
Mr. Carodi, can you message Ms. Nelson and say that she needs to look at her device? Everyone else can hear.
Miss Nelson could not hear, while everyone else could. The court staff attempted to troubleshoot, and the problem was isolated to a single device. It was a small disruption, but it carried a reminder that even in a modern courtroom, technology can fail, and the law must proceed anyway.
All right. So I know that I owe an order on the wiretap. And I just want to clarify, I did deny it, but I just need time to edit. I was in first appearance, I've been in trial, so.
That's fine, Your Honor. For the court's information, since our last court date, we have taken a number of depositions. We have depositions, the last remaining ones set for this afternoon. We have depositions for next Friday, the 17th, for Ms. Gardner's listed witnesses. And I think that should conclude the discovery depositions, absent maybe one or two remaining witnesses.
Okay, does the defense agree?
I think within small numbers or entirely, yes. Meaning there could be a couple that I'm just not thinking of, but we are nearing the end, and it may be that we're done.
Okay. So from Mr. Fernandez, his legal team's perspective, is there anything that we need to do? I indicated that I'm going to go upstairs.
A deposition, for those who are not lawyers, is sworn testimony taken before trial, under oath, with a court reporter present. It is a preview of what a witness will say, and it allows the opposing side to test the story, lock in the facts, and find the cracks that will matter at trial. The defense had taken numerous depositions, and the final ones were scheduled for that afternoon and the following week. The judge then proposed moving the lawyers upstairs to discuss logistics, and the defense asked for hearing time on Monday if the state and defense could not agree on that afternoon's deposition. The judge was amenable and set Monday at 11. The state offered that there was at least a 50-50 chance the issue would resolve by tomorrow, an oddly candid admission that half the time they would be wrong. The judge then turned to the final pretrial conference, which she had not initially set. She wanted it 2 weeks before the trial, on July 27th, and she asked about motions in limine. Motions in limine are requests to exclude specific evidence before trial so that the jury never hears it. They are powerful tools for shaping the case, but they can also be used as delay tactics. The judge made clear that she would prioritize these motions. You all take priority over anything. If you need me to handle them, you just let me know and you advance on my calendar. She offered to give them all the time they needed. All they had to do was ask. The defense acknowledged the offer with a simple, understood. Thank you.
Okay. If you don't need the time, that's fine. I do want to have a final pretrial. I did not set that initially. I'm a little bit hesitant to do it the week before like I normally do. Do you want 2 weeks before? Like the 27th?
Yes.
Yes, and then whatever.
And this is for Mr. Fernandez's case. So his final pretrial will be held July 27th.
And what are you thinking in terms of motions in limine? In terms of like time in between those 2 weeks? I know there's a deadline set because I saw it on my calendar for when they're due, but when were you thinking we would actually hear them?
So you all take priority over anything. That's what the priority order is. So if you need me to handle them, you just let me know and you advance on my calendar. So I'm depending on the parties because you all know the substance of the motions to kind of let me know how much time you need. All you have to do is let me know that and I will advance you on my calendar.
Yes, Your Honor. I'll get with Mr. Dreiser and see what they're going to file, what we're going to file, what we agree upon, and what needs court time.
Right.
Okay, so if you need the time, I'll give you the time. You don't even, all you have to do is ask and I will.
Understood. Thank you.
The parties then announced a significant agreement regarding minor witnesses. The state would not call a minor victim identified as BB, and the defense waived its Confrontation Clause objections to certain video evidence and to statements made by civilian witnesses. The Confrontation Clause, found in the Sixth Amendment, guarantees a criminal defendant the right to face the witnesses against him in person. Waiving that right is not trivial. It requires the defendant to understand that testimony can be presented in a way that would normally be unconstitutional. The defense agreed, and the parties would file a written stipulation.
There was one last issue that we had taken up with the court previously regarding an agreement between the parties as to the testimony of a minor witness, minor victim, BB. The parties have come to an agreement. We're going to put it in writing and file it with the court. And the agreement is that the state is not going to call BB as a witness at trial, so we do not need to have any litigation on competency issues. The defense has agreed to the admission of a video from the scene of the minor child and to waive their confrontation and legal objections to testimony by 2 civilian witnesses as to her statements on scene. I'm going to put that in writing as a stipulation, and the parties will sign and we'll file with the court.
Okay.
We also agreed, we're coming to agreements as to certain witnesses that may appear via Zoom. We have agreed that AB, which is the initials of another minor that we expect to testify in this case, will appear via Zoom.
Will appear?
Will appear via Zoom.
She's a listed witness for the defense. Mr. Dreiser intends to call her. Mr. Carodi has accepted subpoena service from both the state and Mr. Dreiser for AB with the understanding that her guardians would consent to her testimony in Mr. Fernandez's case via Zoom. So we'll sign a stipulation from both state and defense as to Zoom testimony, and Mr. Carodi has accepted those subpoenas.
However, the judge was not finished. She instructed the lawyers to review a 5th District Court of Appeal case that she would send them because it laid out the requirements for remote testimony. Prior to Zoom testimony, she said, there has to be confirmation that Mr. Fernandez can see the witness and the witness can see Mr. Fernandez. That is the main issue. She explained that the witness must be made to understand the seriousness of the proceeding, the oath, and the penalties for perjury. Remote technology does not change the standard. It only changes the medium. She was not hostile to Zoom, but she insisted on compliance with the law.
Okay, so if the stipulation, I want you all to go over, there's a 5th DCA case, I believe. I can send it to you. That you go over that particular case with your clients, Mr. Dreiser with Mr. Fernandez, and the state. I'm going to send the copy to you. So this, there's a requirement. If there's an agreement, it's not that big of a deal. However, prior to Zoom testimony, there has to be confirmation that Mr. Fernandez can see the witness can see Mr. Fernandez. That is a main issue, and I don't think that it should necessarily be an issue because of 407 and how it's going to be set up, but all those things have to be confirmed for the record, and then it specifically addressed the confrontation waiver. Okay?
And we should be able to take care of that. She's a defense witness, so I don't think.
She's also listed by the state.
I think the waiver of confrontation will be something we can take care of.
And then having said that,
It was actually in this courtroom. I think Judge Soud wrote, it was an affirmance, but Judge Soud wrote
Yes, sir.
a concurrent opinion that I think gives guidance to any.
The state then asked the court to formally deny its motion regarding the minor witness, and the judge obliged, asking for a formal order. That matter was resolved, but the prosecutor had another issue. He raised a concern about the court's order on the timing of filing motions. He argued that the state would be in trial when the Gardner defense's deadline arrived, and he wanted the Gardner motions to be filed 5 days before the Fernandez motion deadline so that they could be heard together. He did not want to be caught off guard by motions filed while the state was trying a case. The judge asked the defense for their position, and the defense replied that they could not yet identify specific motions, but had relied on the court's existing order. The judge suggested they discuss it on Monday. Then came the moment that defined the hearing. The judge looked at the lawyers and said, "All of you are very, very experienced lawyers, so I am hoping that we are not going to be litigating things that are just accepted law. It should be related to perceived evidentiary issues that are real, not boilerplate."
What's the defense position on that? Do you have, let me ask it this way. Are there motions that y'all are contemplating that could be filed ahead of the Fernandez jury selection?
Judge, at this time, I can't tell the court that there are any specific motions. I'm sure there will be. We have relied on the court's order, as to that deadline.
Right.
Mr. Mizrahi, he brought it up to me this morning. I'm just not in a position
Okay.
today to address
Can
it.
you talk about it and we address it on Monday?
Yes, sure.
All of you all are very, very experienced lawyers, so I'm hoping that we're not going to be litigating things that are just accepted law. You know what I mean? It should be related to perceived evidentiary issues that are real. You know what I mean? Not boilerplate.
Yes, Your Honor.
Yes, ma'am, of course.
The hearing concluded with the judge confirming that the defense had met with their clients, especially given the use of Zoom, and she set the next hearing for July 13th at 11 in courtroom 407. Then she recessed. What happened in that hearing is the essence of the silent objection. The prosecutor made a specific request, rooted in a legitimate concern about being unprepared during trial. But the judge had already addressed that concern by offering flexibility, priority, and time. She told him that all he had to do was ask. Yet he persisted, and the judge persisted in her calm response. No one objected to her suggestion. No one said she was being unfair. The silence in the room was the objection. The acceptance by every lawyer that the judge was right, that they should not waste the court's time on accepted law, and that the prosecutor's worry was already solved. The evidence simply spoke, and no one needed to raise their voice. This is the legal lesson that extends beyond this courtroom.
To the extent, it's hard for me to do that because when they're separated in that way,
From the state's perspective, having it 5 days before Fernandez, just like the Fernandez order says, doesn't put an undue burden on the defense to have their motion limines done, 3 weeks before as opposed to 5 days before. I don't think it's that unreasonable. And the same would hold true for the state if we have any in the Gardner case, that we would file it early. I just think if we're going to have motion limine hearings the week of the final trial, we should do both defendants as much as we can. I'm not going to say that they can't raise something up, but we're trying to comply with the court's order. I just didn't want to be inundated with some motion limines while we're in trial. That's what I'm trying to prevent.
Your Honor, I can say first that we'll try and file motions as soon as we know we're going to file them. Second, though, I do respectfully disagree with Mr. Mizrahi. When the trials were severed and they were set, that sort of set our preparation timeline as to how we are preparing. I believe that the additional 3 weeks that we have, we'll work that into trial preparation. So I don't think that we should be held to the same timeline as Mr. Fernandez, who has had ample notice of his deadline for months.
okay. I'll take a look at it. I'm going to ask